Okay, everyone, this is Kirk Bankstead, streaming live from the United County Courthouse. We were just told that we could not present our presentation today using our PowerPoint presentation. Carl Jenrich is here. He is the zoning committee member. He also said that they would not allow us to present our case today. He's actually the one who has given us all these code violations to start with. So the fact that he is the one making the decision that we can't actually present our appeal today seemingly is a conflict of interest, because we're actually fighting against Carl's zoning committee. So we're at a standstill at the moment, but if they force us to go through this meeting without being able to present our presentation and without being able to present exhibits, that is a direct violation of due process. The meeting is starting.
Joined by several people in the room. Our attorney, Mr. Ron Saylor, and other people that would like to be part of the presentation.
I'm Kirk Bankstead. I own the Minocqua Brewing Company. We're here to talk about my property today.
Frederick Melms, attorney for Kirk Bankstead, the Minocqua Brewing Company.
Mike Dugal, for Oneida County. Carl Jenrich, zoning director, Oneida County. And Carlos just that. Relationship with Minocqua office.
Okay. You, sir?
I'm Andrew Jones. I'm outside counsel for the county. I'm not anticipating that I'll be addressing the motions.
Thank you. So we will hold the hearing for the request from the Minocqua Brewing Company to.
But we will do it on a TV or a projector. Somebody's projector. We don't have a projector. We need to ask for a projector.
Okay.
Can you ask Fugel for a projector? Because he's going to keep
The
going.
revocation.
Revocation of the.
But he won't stop the meeting.
So the way that this will proceed, we will hear from Mr. Bankstead or his representative, and then from the county, we will have a chance to ask questions, discuss, and then we will close the hearing for a decision. And what we are actually here to hear is if the revocation of the conditional use permit was appropriate or not.
And Mr. Chair, before we start with anything, I would like to ask a question of all of the members of the board and ask them if they can answer this either yes or no in a roll call fashion, and that is, can you set aside anything that you may have heard right now before today about the facts of this matter or the parties involved in it, and reach your decisions based just upon the evidence that is presented to you here today?
And make a roll call vote on that, Mr. Ross.
Yes, been doing it for 13 years.
Mr. Patrick.
Yes.
Mr. Cronister.
Yes.
Mr. Viga.
Yes.
Mr. Harold. And Mr. Verdun.
Yes.
And myself, Hanson, is also denied. Thank you very much.
Thank you. And I think perhaps before we turn it over to the parties, I understand that Minocqua Brewing has an issue in regard to its exhibits, so we'll talk about that. But I wanted to talk first in regard to what the issues are today and what the issues aren't.
You need to talk to Fugel
Parties have submitted
right now.
pre-hearing briefs or memorandums to the board, and I think that a consideration of some of those issues that were addressed will help to at least focus or streamline what we do today. The first part of that is in regard to the issues that were addressed in Mr. Melton's brief. In section 2, he raised issues in regard to the allegation that the county is using the zoning process as a tool of political retaliation and suppression of free speech. Those would be First Amendment issues. He's raised issues in section 3 that the county engaged in selective enforcement of the zoning ordinance. Selective enforcement of the zoning ordinance.
Get a projector screen from the county clerk. She's right here. I'm gonna go look for a
And
projector.
then in section 5, the appellant has raised issues of unconstitutional conduct of the Oneida County Planning and Development Committee and has a bunch of allegations in regard to that. All of those are allegations of constitutional violations, which the Board of Zoning Appeals does not have power to address. So we are not going to be entertaining argument or fact today in regard to the issues raised in sections 2, 3, and 5 of the appellant's pre-hearing brief. We're not going to be addressing constitutional issues. Another section of the appellant's pre-hearing brief was in regard to section 4, where it argued about whether the conditions of the conditional use permit were inappropriate, or as they allege, were not genuine regulatory measures, but strategies to keep Minocqua Brewing Company in a precarious position. Those are not issues for today as well. Those are issues in regard to the actual conditions of the conditional use permit. County ordinance requires that if you seek and obtain a conditional use permit and you want to challenge the conditions of that permit, you have 30 days to do that, and you have to do that through an appeal process. That appeal process was never invoked, never raised, and so the issue in regard to whether conditions of the conditional use permit are appropriate, good things, bad things, should be bigger, better, faster, slower, those are not at issue today. What is at issue today is whether the conditional use permit should have been revoked. And so the committee would like the parties to keep their evidence and their arguments to that issue and that issue alone, please. Mr. Mellis, did you have an issue in regards to slides that you wanted to present?
Yes, we have a number of slides we'll be presenting. I think we're getting a projector though, because I believe there were some concerns about using the AV in here.
Okay, so is there an issue or is there not an issue?
I don't know, actually.
Okay, well, we'll find out when that arises.
Yes.
Carl, can you address the slide issue?
Yes, it's just the policy of our IT department that if someone brings in zip drives or any other type of devices and wants to plug it into our system, we cannot do that unless IT has a look at it and scans it. And again, I just talked to the director, 5 minutes ago, and he said the same thing. Absolutely nothing to be hooked directly into the system. So he looks at it.
That's Oneida County policy.
Yes, for example, we get complaints all the time when people want to bring in zip drives with pictures on it, and I can't even grab those pictures from that zip drive.
Well, we'll see if it becomes an issue.
Okay, so for the record, this hearing will be conducted in accordance with the Wisconsin Open Meeting Law, and the meeting will be recorded. Our board is made up of the 5 regular members and 2 alternates. All 5 of us will be, all 5 of us will be involved in the discussion. All 7 of us will be involved in the discussion, and we'll close the hearing, and the 5 will vote on the 5 regular members will vote on the decision. Those who wish to testify in this matter should stand at this time and be sworn in. Anybody that wants to testify?
We can also do it individually as people are presented. Maybe that would be better.
I think that would make more
In case things
sense.
change.
So we went to go get a projector, I
Okay.
believe.
Okay. We did not have an on-site hearing, so we will proceed with the hearing. We did not have an on-site visit.
Certainly.
Oh, here we go. Did you get one?
There's no more projector screens in the county apparently because it's old technology. But apparently the new technology is it's too dangerous for my computer. But apparently the federal government's okay with Elon Musk tapping into that.
So at this, we're gonna swear in people individually as they would like to testify.
I'm not gonna go forward like this. We're out, sorry. This is a violation of due process. If we can't give our presentation, there's no point in us being here.
Well, Mr. Banks said, we don't even know what you want to present yet. We don't know if the exhibits that you have on your slides are relevant to any of the issues. You were absent from the room when we talked about the issues.
I was looking for a projector screen because you guys can't get yourself act together to actually allow us to present our appeal.
Your appeal can be presented. So if you have slides that you think need to be presented, and you can describe those for us and tell us why you've been prejudiced by not being able to, we can deal with them individually.
We need to print them out so I can disseminate them so you all can look at them and see if they're relevant or not.
We don't know that until you've presented it. So why don't you present your case, and we'll see if we run into issues.
Are we ready to present?
All right, let me swear you in. Do you solemnly declare and affirm the testimony and other evidence you shall give in this matter shall be the truth, the whole truth, and nothing but the truth to the best of your knowledge under the penalty of perjury? If so, respond by saying, I do.
I do.
Thank you very much.
So just a point of order. When we present an exhibit and it is deemed potentially relevant for the discussion, will there be somebody to actually go and make photocopies for all of the members of this board? For every single one? There's 28. There won't be. So how am I supposed to present an exhibit even if you deem it relevant to this committee and yet you're supposed to make a decision based on our appeal at this meeting?
So these relate to whether the conditional use permit was improperly denied?
Yes.
Revoked?
Yes, it does.
If you have a relevant slide that you want to show, and you can't show it because you can't hook up to the IT system, you can put it on your screen and walk it around.
How about I cut a check to the IT guy for $500 right now, so that anything that might happen, and there might be overtime that he needs to incur in order to fix whatever virus that you think might be on my computer, he can hire somebody outside of government to fix it so that I can present the exhibits that I'm hoping to present today.
You can show the exhibits to the members of the committee on your computer screen, and after the hearing, we would ask that you supply a hard copy of any of those pictures to the record.
Okay, so you're saying that if you take a vote that allows me to present my exhibits, then you want me to walk around to the room and show you all my computer screen?
Yes.
Okay.
And I'm not asking you to do that now. What I'm saying is, if you have an exhibit to present, identify it for the committee. If it's relevant for their consideration, you can present it.
By the way, part of the reason we're here today is because the zoning committee, I've probably done about 10 to 15, been called in to the zoning board about 10 to 15 times along the town of Minocqua. Never have I been able to give my side of the story. I've always been cut off. So this is part and parcel of the same process, unfortunately.
Nobody's cutting you off today. We're giving you the opportunity.
We'll see that. We'll see if that happens.
Every exhibit you'd like to present.
Okay. So to the Oneida County Board of Adjustment, I come before you today to appeal the revocation of my conditional use permit. The appeal challenges the arbitrary, unreasonable, and unconstitutional enforcement actions taken by the Oneida County Planning and Development Committee, which illegally revoked their Minocqua Oh, really?
Mr. Banks, let me stop you because you were out of the room when we started this. And when we started, and I'm going to repeat this again for your benefit so that you understand it as well. Your attorney submitted a... You need something?
No, I'm making sure that the TV's catching you cutting me off when I'm trying to give you an appeal.
I'm not cutting you off. There are procedures that we need to follow. There's information that everybody needs to have. And so if you would listen to what I have to say, you'll understand the scope of what we're here today for, and you'll be able to address that with the evidence you want to present, okay? Is that fair? Is that fair?
you're telling me what I'm allowed to do is fair in terms of you're telling me what I'm allowed to do. Whether or not I agree if it's fair that I'm not allowed to talk, I don't agree that that's probably not fair, and I believe it's probably illegal.
Nobody has told you that you can't talk, and I think I've told you now 3 or 4 times. We're going to give you the opportunity to present any evidence that you want to present today. You're going to have the opportunity to call any witness you want to testify today, and you're going to be able to present any exhibit you want to the Board of Zoning Appeals. So let me tell you what we see the issues as today. I'll start over. Your attorney submitted a pre-hearing brief, and in your attorney's pre-hearing brief, he raised 5 different arguments. Argument set forth in section number 2 says that there's an allegation that the county used the zoning process as a tool for political retaliation and suppression of free speech. Those would be First Amendment violations. Those are constitutional issues. The Board of Zoning Appeals has no jurisdiction or authority to rule upon constitutional issues. We won't be ruling on those issues today. Testimony and evidence in regard to the alleged political retaliation and suppression of free speech is not an issue here today. In section 3...
But it provides context, does it not?
No.
Yes, it does, actually. Are you the attorney, or are you just the head of the committee?
I'm the attorney.
I thought Fugel was the attorney.
I'm the attorney for the board. I help the board understand the legal process that it needs to follow.
Did Fred agree with you that that has no context to what we're talking about today? He's my attorney.
It doesn't matter whether Mr. Melms agreed with me. This is what the committee has discussed, and this is what the committee is going forward for. So section 3 of your attorney's pre-hearing brief raised an allegation that the county engaged in selective enforcement of the zoning ordinance. Selective enforcement is rooted in the Equal Protection Clause of the 14th Amendment. That too is a constitutional issue. We won't be addressing issues of selective enforcement today because it's a constitutional issue that this committee does not have the jurisdiction or authority to address. In section 5 of your attorney's pre-hearing brief, he raised the issue of the allegation of unconstitutional conduct of the United County Planning and Development Committee. Again, that is a constitutional issue that raises issues that this board is not authorized to address and has no jurisdiction to address. We won't be hearing issues on that. In section 4 of your attorney's pre-hearing brief, he raised allegations about the conditional use permit conditions being inappropriate, not genuine regulatory measures, and have somehow been designed to put you in a precarious position. The conditions of the conditional use permit were approved back in 2023 when the conditional use permit was issued. If you had challenges as to the appropriateness of conditions for the conditional use permit, you were required to raise those back then within 30 days of the issuance. That's not an issue today. What is at issue today is whether the committee was correct in concluding that it should revoke your conditional use permit because you weren't in compliance with the terms of the conditional use permit. So I would ask you on behalf of the committee to confine your argument, your evidence, and your witnesses to that issue. Do you understand that?
Yes, I do.
Thank you. So please proceed.
And I will assert, my right to be able to speak in front of this august body with things that I feel are important for them to hear. And I think we all have rights. And I think I've spent about 4 years simply trying to tell my story. So I'm going to proceed to tell my story.
We're not here.
And if you don't want to hear it, then you're going to need to physically remove me from this place.
Mr. Bagstead, you can have a platform in many different places to address your story. This isn't the platform for addressing your story. This is the platform for addressing whether you violated the conditions of your conditional use permit and whether the committee had substantial evidence to reach a conclusion that it should revoke that permit. If you're going to stand up there and insist on addressing other things, the chair will rule you out of order, and then you can sit down and call other witnesses to do other things. But this is not your bully pulpit to stand up and argue about things that don't pertain to the issues here today.
You've decided this legally outside of a judge, and you never told us that these were going to be the preconditions of coming here today.
We're
So-
telling you that today.
Well, because you told us today, we are not prepared to amend our appeal because we came with the full assumptions. My attorney talked to Attorney Fugel to make sure that we understood the ramifications of and the parameters of this meeting. We came into this meeting fully expecting to be able to present our exhibits and fully expecting to be able to read about the context of why we think our conditional use permit was revoked. That context involves political retaliation and harassment. So if you're not allowing us to talk about that today, then I think that our due process has been violated because you did not inform us of the parameters. We submitted a brief to you, which we fully intend to support that brief today, verbally, and you didn't tell us that you were going to limit our discussion of that brief.
What we are telling you today is one of the issues
Today.
you raised is entirely germane to your appeal. Is there substantial evidence that you were in violation of your conditional use permit? And was the decision made by the committee rational? You have the floor, you have all the process that is due to you to put on any witness, any testimony, and any documentary evidence that you wish to address that issue.
Okay.
That's the issue today.
So if the chair deems that what I'm saying is out of context, I will probably disagree with that. And so I'm preparing you that I'm going to continue to read from my prepared statement.
Please don't do that.
And if you don't like that, then you can call a judge. Because I believe that what you have done today is a violation of due process. You as an attorney can tell me it's not, but I don't believe that is the fact. And I think a judge needs to be called in here to decide that.
I also think, despite the existence of due process here, that these limitations are getting to the point where you're running into some petition clause issues in the First Amendment. I believe Mr. Bankstead has a constitutional right to petition his government when aggrieved. He's here to do that, and I think the conditions really interfere with that.
I would respectfully disagree with that. He has the right to present today evidence in regard to the issue of whether the committee's decision that he violated the terms of his conditional use permit was supported by substantial evidence and an appropriate decision. So please proceed on that.
Has Oneida County hired, you're the insurance company lawyer, right? Oneida County Insurance has hired you because they don't necessarily think Fugel is up to this task of making sure.
There's a conflict.
What's a
Yeah,
conflict?
Mr. Fugel can't sit there and here.
No.
Okay, so you weren't hired by the insurance company though, right?
It doesn't matter who's paying my bill. I'm here to advise the committee.
Okay, so I'm going to advise you that due to my First Amendment rights and my ability to petition the government, that I'm going to read my prepared statement and present my exhibits. And if you don't like that, then you can call a judge, or you can physically remove me from this room.
Mr. Bankstead, you misunderstand. Maybe you want to confer with your counsel for 5 minutes because you seem to not be understanding the scope of the proceedings and how this works.
Don't be rough with me, brother. So I've conferred with my attorney, and we thought really deeply about the First Amendment, and we thought about due process. And I've decided that, in order to get a fair hearing here, I need to read my prepared statement. So I plan to do that now. And if you don't want to hear certain aspects of it, then it's up to you to do what you feel the need to best. Now, the issues that we need to talk about here are you didn't give us prior parameters. So if we have to go to court after this, I think as an attorney you will understand that not telling us how this meeting was going to go, and I think your board should hear this because there's probably a future lawsuit here. If by not telling us ahead of time the parameters that you would allow us, how we would present our own appeal, you violated due process. So that being said, we've laid the groundwork. I'm going to read my statement, and I hope you let me get through it because I believe it's all very relevant to why we're here today. Dear Oneida County Board of Adjustment, I come before you today to appeal the revocation of my conditional use permit. This appeal challenges the arbitrary, unreasonable, and unconstitutional enforcement actions taken by Oneida County Planning and Development Committee, which illegally revoked the Minocqua Brewing Company's cup despite substantial compliance with its conditions. The revocation of our cup was not based on legitimate zoning concerns, but rather on selective and bad faith enforcement
Relevance.
designed to obstruct MBC's
Bangstad,
lawful
Mr.
business
Bangstad.
operations.
Mr. Bangstad, when
Do you want me to
Bugle-
keep going?
No, I want you to stop, please. When Mr. Bugle raises an objection, you have to give me the opportunity to rule on the objection. Okay?
Gotcha.
Thanks. What's the objection, Mr. Bugle?
Relevance. He is raising the issues that were specifically excluded from this discussion today.
So one of those issues was not specifically excluded that he just raised. I guess specifically, there's the issue that the Planning and Development Committee seemed to be adding conditions to the conditional use permit as the process went on. Specifically, it was adding the diagram basically as a condition of the conditional use permit, even though it wasn't named as a condition of the conditional use permit. So within that, there are a number of sort of arbitrary and capricious conditions that were placed on Mr. Bangstad at these hearings that were not within the conditional use permit itself, and I think very relevant to raise here.
Mr. Rollins,
If you want to testify, we need to swear you in.
well, he's just making arguments, so that's appropriate, but I agree with you that the issue that you just identified would be relevant to the proceedings today. The objection was to Mr. Bangstad's testimony, which isn't relevant. So, Mr. Bangstad, it's irrelevant. Please move on to something else.
Okay. This appeal seeks to reverse the revocation and ensure that zoning regulations are applied fairly, consistently, and in accordance with constitutional protections. The record demonstrates that my business and I have acted in good faith to satisfy the cup conditions, that many of the conditions imposed upon me were arbitrary and capricious.
Objection.
And that
Relevance. The
I'd make
time
the same
to
argument.
raise an appeal relative to the conditions expired 30 days after the issuance of the permit.
There were additional conditions placed on Mr. Bangstad and Minocqua Brewing Company at the planning or at the zoning and development committee meetings that were not within the cup.
I think if Mr. Bangstad wants to offer testimony about some alleged additional conditions that were being imposed that weren't actually contained in the conditional use permit, that would be relevant. But again, rather than reading a statement, Mr. Bangstad, you could talk about facts that support some of these things.
Can I ask the members of the board whether it's really worth your time to have everybody object to everything that I say? Wouldn't you rather just hear my story? I've really spent a lot of time here outlining what I think is important in order to keep my business open. This is my livelihood in Minocqua. I'll go broke if you decide to revoke my permit to do business. Don't you think it's relevant, given that I will go broke depending on what you decide today, that I should be allowed to read my statement? It's a simple thing.
You can read your statement that relates to the allegations of whether the revocation of your conditional use permit was not supported by substantial evidence, and the committee's decision shouldn't be upheld.
Members of the committee, this is not a judge that's ruling this meeting. He's a lawyer. You have the right to ask your chairman to just simply let me read my statement and talk to you about why I feel you shouldn't be shutting me down today. Do you think that's relevant? Each of you have the power to just say, okay, Kirk, just say your stuff, or else it's just going to be complicated this whole time. If you vote to shut me down, that's fine. But just let me say my piece, would you?
Please stick to things that are relevant to the issue of whether you violated the conditional use permit and whether there was substantial evidence to show that you violated the conditional use permit and whether the committee's decision was rational and reasonable.
Just remember, members of this committee, you didn't speak up when you had a chance. You had a chance to do the right thing, you didn't speak up. You let an insurance company lawyer decide how this was going to go. And you were the
Objection,
people elected.
relevance.
The record demonstrates, that's fine, I accept that objection, I'll move on. The record demonstrates that my business and I have acted in good faith to satisfy the CUP conditions, that many of the conditions imposed upon me were arbitrary and capricious, and that the county's actions violate established legal principles governing land use and substantive due process.
Objection, relevance.
Mr. Banks said we're going to be here for a long, long time just ruling on the objections. So I'm going to advise Mr. Melms, if you have factual testimony to present on the issue, could you guide your client through that?
Certainly.
Thank you.
Thank you for your guidance, my friend. Accordingly, this presentation will outline the factual background, legal framework, and constitutional violations that warrant the reinstatement of my CUP and the rejection of the Oneida County Planning and Development Committee's unlawful and retaliatory enforcement action.
Objection, relevance.
Mr. Bankstead, I understand you want to read this statement, but you're wasting the board's time by trying to put on your opinions and testimony about issues that are not before the board today.
All of these issues are before the board.
The board has no authority and no jurisdiction to rule on the issues you want to address.
It's a contextual, it's all contextual.
It's
So
not
Mr.
contextual.
Holwinski, who originally has it out for me, also did
Objection.
not allow me to speak
I think
at
that's
these
relevant.
meetings.
Objection.
So
I'm
by
gonna
you
ask
not
that be
allowing me to
stricken from the
speak
record.
continuously on why I feel I'm being shut down and you're erasing my livelihood, that to me is completely relevant. What I'm saying today is trying to save my business. You have the power to close my business. Why would anything that I've written to try to save my business be irrelevant to you shutting it down?
The issue here today is not whether this board is shutting down your business. It's whether this board finds that there was evidence that you weren't in compliance with the conditional use permit, and that as a result of that, the committee had substantial evidence to conclude that it could revoke your conditional use permit. So Mr. Melms, I would ask if you have a case to present that you call the witness and guide the witness through a question and answer. Otherwise, we're just going to consider this to be an opening statement and it's of no evidentiary value.
I certainly understand.
I believe, I'm hoping that this is evidence, but I'm going to keep reading. I hope that's okay with you. I'd like to be able to present the reasons I should be allowed to stay open.
So, Mr. Melms, here's what I'm going to direct you. If you have a factual witness that you want to present factual testimony, you can do that through a question and answer of the witness.
Certainly.
Otherwise, we are going to consider this to be an opening argument by Mr. Bankstad. He can read it, we'll let him read it, but it is not of any evidentiary value, and what you say in your opening, Mr. Bankstad, will not be considered by this board in reaching its decision. So you can have your pulpit to make your speech and to lay out your allegations, but what you're saying is not going to be considered to be evidence. Do you understand that, Mr. Jones?
I do.
Thank you.
I appreciate that. Thank you for offering me the opportunity to at least say my piece, which I've been trying to do for years now. I'll start again. Dear Oneida County Board of Adjustment, I come before you today to appeal the revocation of my conditional use permit. This appeal challenges the arbitrary, unreasonable, and unconstitutional enforcement actions taken by the Oneida County Planning and Development Committee, which illegally revoked the Minocqua Brewing Company's cup despite substantial compliance with its conditions. The revocation of our cup was not based on legitimate zoning concerns, but rather on selective and bad faith enforcement designed to obstruct MBC's lawful business operations. This appeal seeks to reverse the revocation and ensure that zoning regulations are applied fairly, consistently, and in accordance with constitutional protections. The record demonstrates that my business and I have acted in good faith to satisfy the cup conditions, and that many of the conditions imposed upon me were arbitrary and capricious, and that the county's actions violate established legal principles governing land use and substantive due process. Accordingly, this presentation will outline the factual background, legal framework, and constitutional violations that warrant the reinstatement of my cup, and the rejection of the Oneida County Planning and Development Committee's unlawful and retaliatory enforcement actions. Before I get into the details, I'd like to start by offering a brief history about the Minocqua Brewing Company under my ownership. I've owned the Minocqua Brewing Company for over a decade. In our first iteration, we operated solely as a brew pub on 238 Lakeshore Drive. I'm sure many of you might have been there. And we focused on serving food, brewing craft beer, and offering live music. During this period, MBC built a strong reputation for great beer, great food, and great music. We became a staple of Minocqua's community and a highlight of the town's social scene. However, when COVID-19 hit in 2020, the pandemic forced businesses across the country to close their doors, and we were no exception. Like many hospitality businesses, the brew pub struggled under lockdown restrictions, ultimately leading to our closure. But around the same time, I became increasingly politically active, using our building to display large political signs in support of Democratic candidates. My activism gained traction, and as my visibility grew, so did my resolve to integrate politics into my business. We began selling Biden beer, a move that resonated with progressive supporters and further solidified NBC's identity as a politically engaged brand. By the beginning of 2021, I had sold the Lakeshore Drive location, but my vision for our business was just beginning to take shape. Determined to expand NBC beyond a brew pub and into direct public engagement, I purchased the historic Texaco gas station at 329 Front Street in early 2021. My goal was to transform the dilapidated building, which many of you know as Z-Best Bikes. I was determined to transform that building into a tap room and a community gathering space. Unlike the previous brew pub, this location wasn't just a place to enjoy food and craft beer. It was designed to serve as a hub for progressive activism, political engagement, and grassroots organizing. With the new tap room, I created a space where like-minded individuals could come together to discuss political issues, share ideas, and support progressive causes. The shift from a traditional brew pub to a tap room with a strong political identity marked a turning point for my business. What had started as a craft beer brand evolved into a symbol of resistance against right-wing extremism and political suppression in Wisconsin. This transformation, however, made my company and me targets for retaliation by local government officials and conservative activists who opposed my outspoken advocacy. The legal battles that have followed weren't just about zoning permits. They became a fight for free speech and political expression. Today, the Minocqua Brewing Company tap room at 329 Front Street in Minocqua operates as a progressive hub. And that shouldn't be a scary word for anybody. We just talk about politics there. It might not be the politics you agree with, but it's what America was designed to do. That's what democracy is designed to do. Talk about politics. The tap room serves NBC's signature politically themed craft beers, wines, and sodas, including popular selections such as Resistance Pilsner, Snowflake Holiday Ale, Labor Lager, Woke Coffee, which I hope you might laugh about because it's kind of funny, and Choice Wine. In addition to drinks, NBC sells merchandise that reflects our progressive values, such as t-shirts with slogans like trans rights and truck country, choose reason over treason, and drink progressively. The tap room is more than just a place to enjoy craft beer. NBC has become a central gathering place for political activism in the North Woods of Wisconsin. The tap room regularly hosts community events and its signature beer tastings that double as political rallies. These events provide an opportunity for attendees to engage in conversations about local and national politics, the state of our great country, and organizing efforts. I speak frequently at these gatherings, using them as a platform to, yes, criticize local government officials, but also advocate for progressive causes and mobilize my supporters for political action. Beyond its political mission, NBC has become a major tourist destination, attracting tens of thousands of progressives from the country all summer. Supporters travel to Minocqua specifically to visit my tap room. I guarantee you this. A lot of these people have never heard of the word Minocqua before until they found out about my brew pub. They visit my tap room, they enjoy my beer, and they experience the political atmosphere firsthand because they can't believe somebody like me is so loud and outly progressive in such a red area. Not only that, but I put Minocqua on America's architectural map by going through the lengthy and expensive process of having this exact replica of a 1930s Texaco gas station be accepted into the National Register of Historic Places, the only public building in Minocqua to have that distinction. The influx of visitors to the tap room, both for political and architectural reasons, significantly contributes to the local economy, bringing revenue to nearby restaurants, hotels, and other businesses. The hotels around me might all be run by conservative folks, but they're making money off of me because I'm getting people into Minocqua that have never been here before. Despite this economic benefit, NBC continues to face harassment and selective enforcement by local officials intent on shutting us down. Even in the face of these obstacles, we remain a thriving business and symbol of progressive resistance in conservative northern Wisconsin. The taproom has built a loyal customer base not just in Minocqua, but across the country, with many supporters purchasing our craft beer and merchandise online. Through social media, direct activism, and legal battles, we have established ourselves as a unique fusion of business, politics, and advocacy, standing firm against efforts to silence us, like you've witnessed already here today. Now that I've provided a little background, I'd like to outline the history of the zoning dispute and selective enforcement of zoning regulations and ordinances against the Minocqua Brewing Company to give context to why my cup was revoked, an exact correlation to why we're here today. The town of Minocqua and Oneida County's efforts to suppress my company date back to 2020, when I placed a large Joe Biden for President sign on my building. The sign enraged local officials, prompting the Oneida County Planning and Zoning Department to threaten me with daily citations unless I removed it. I would like to present the letter from Carl Genrich that shows that I was being threatened with daily citations against U.S. Supreme Court President, which is Reed versus the town of Gilbert, which said that counties and towns cannot regulate the size of political signs. Can I present you that slide?
I'm going to object that if this is argument, as it was stated, then let there be argument. I have a standing objection to this diatribe, but I mean, if there's evidence that's going to be presented, then I would ask that we move to an evidentiary phase. Because at this point, my understanding of this presentation is that it has no evidentiary value whatsoever, and so it's not appropriate to introduce any evidence.
And that is correct. This is, and you were told this before you started, Mr. Bankston, this is an opening statement. So you don't need to present evidence in your opening statement. Your attorney will have the opportunity to present testimony and exhibits when you're done. I will note though, so far, you have read nearly verbatim from the pre-hearing brief that you submitted to the board.
That's not true.
That is,
nearly verbatim. So if that's all you're going to do, save us the time, because we're not gonna sit here and listen to you read 20 pages of what we've already read.
Because he just objected, you were letting me talk, and now he objected, and now you're not letting me talk. So I would argue that Fugel just violated my ability to be able to just say what I asked to do and you allowed me to do. Now, and I also suggest that...
Mr. Bangstad?
It's-
Mr. Bangstad, you're giving an opening statement, you are free to testify. If there's an objection...
But I'm not free. You haven't allowed me to be free. You've
If you have an
regulated
objection
everything
to be
that's
made,
coming
you have
out of my
counsel
mouth.
here who's representing you, and objections are made through counsel. So, Mr. Melms, do you have an objection?
I think my client would like to continue with his opening statement.
I will say this, if you just continue to read what we've already got in front of us, we're going to ask you to stop and move on to the point where we get some testimony.
Are you a judge?
I am today.
Okay, well, I would suggest that as a judge, you understand that if you don't allow me to speak after you just said you were going to do so, that seemingly is like changing your mind midstream,
No,
which can't be,
you're
it can't
abusing
be
the
right.
process, Mr. Bangstad.
I'm not refusing the process. You didn't give us the process until we showed up today.
I didn't say refusing, I said abusing. You're
Abusing the process. I'm
By
simply,
wasting the time of the Board of Zoning Appeals by standing here and reading.
who's
to us-
wasting time now?
You are.
You just stopped me. I wasn't wasting time. I was trying to get my statement that I prepared for you read. And now,
You've read your statement,
Fugel
so
has
if you have
stopped me.
something to say it.
I'm saying it, but I also want to present the exhibits that I've shown you today, that I prepared for you today.
We will do that through the examination of witnesses and exhibits that Mr. Melms will be.
Where will that be done? You
Right
don't
here today.
you don't have a TV. The only exhibits that exist are on my computer. How are we supposed to get the exhibits out to your committee?
Mr. Bangstad, if you have an argument that you want to present as your opening argument, please continue. But I'm going to ask you one last time. Don't just read from what you've already submitted, because then we will just ask you to stop and we'll move on.
this is insulting to the board. We've all received this information and we've all read it, and it is word for word, as from what you submitted.
It's not word for word. I mean, I literally guarantee you, it's not close to word for word.
We're not going to debate whether it's word for word or nearly word for word, so please move on.
Okay, point be taken though to anybody listening right now and to the board that in my opening statement, probably 80% of the points that I wanted to make to this board were visual, because I know that not all of us are just hear stuff and get it, including me. I like to see things when I make a decision, especially one that's so important to a man's livelihood. So just hearing an opening statement without seeing exhibits, we all know we're visual people. And when it comes to zoning, a lot of this stuff is actually recorded in pictures. So I would submit,
We'll get those in.
I would submit that you allow my attorney to show those exhibits
They're going to.
after this.
They're going to.
They're not going to. They didn't say they might not.
Mr. Bangstad, this is like the third time we've been over the same ground. If you have an opening statement that you want to present and it's not reading from what you've already submitted, please proceed.
After publicly exposing the county's efforts to silence me, the Planning and Zoning Committee backed down and my Biden sign remained. But my defiance placed a target on my back. Ever since then, Oneida County and the town of Minocqua have systematically weaponized zoning ordinances to harass NBC and obstruct its ability to operate. The revocation of NBC's 2024 conditional use permit is the culmination of this ongoing campaign and political retaliation. Now, I'd like to get into the details of how Oneida County's zoning process has been used as a tool of political retaliation and suppression of free speech. First off, the county's efforts to silence me were premeditated. Oneida County began orchestrating its campaign to silence the Minocqua Brewing Company and me almost immediately after I purchased the building at 329 Front Street.
Mr. Bangstad.
On March
Mr.
15th,
Bangstad,
2021,
Mr. Bangstad,
yes, sir.
you continue to simply read from your pre-hearing submission.
Have you
which
guys
the-
come here? Have you ever seen my
Mr.
brief?
Bankstead,
Have
please
you
don't
guys seen
address
my
the
brief?
crowd.
This is a public meeting, am I not correct?
This is a public hearing.
A public hearing. So the public has a right to hear my statement. Is that not true?
That is not true. The public has the right to hear the evidence that you submit in support of your case.
I'm submitting it.
No, you're not. Right now, you're trying to give an opening, and all you're doing is
Trying
reading.
real hard.
Mr. Bankstead, this isn't a game.
I'm trying to not
Do you
become
have
completely.
something to tell us that
I-
is not written in your pre-hearing brief?
Why do you suggest that it wouldn't be appropriate for the members of this committee to hear what I have to say?
Because
Mr. Stadler,
we're an hour into a 20-page pre-hearing brief that you're reading to us, that the members of the board have already read, and we're not gonna sit here for another 4 hours listening to you read what's been submitted.
You
So
have
either do this.
zoning
You-
committee,
Mr.
sir,
Bankstead.
can you
No.
listen to me for a second?
No, I'm
This
not.
zoning committee has made me lose about 500 hours of my life and my treasure.
Banks-
Mr. Stadler,
Yes.
I would like to remind Mr. Melms and his client of document 73 in case number 24CX02, in which Mr. Bankstead was told by Judge Bloom what was and was not appropriate behavior at a meeting. And while that does not apply to this meeting,
That's out
I
of
would
order.
ask this be
It's not
stricken.
relevant to this hearing right now. Why are you doing things that are out of
Mr.
order, sir?
Bankstead, you're not the judge here. So
But are you a judge? You're the insurance hired lawyer to protect this committee from violating due process, which you are
Correct.
not doing very well.
Correct. Please confine your remarks to when it's your turn to speak. Right now, Mr. Fugel's making an objection, and you don't get to object him during the middle of it.
You'd
Mr.
allowed me
Fugel,
to
you
speak.
can continue your objection.
He's got a standing objection.
I
You
would
just said so.
object the introduction of an order that was directed at a different zoning meeting, and
I
ask
think
that
it gives
it's
us context.
and ask that ask that
Absolutely.
it be stricken.
Okay, let it happen. Let it happen. If as long as we're going to let people give context, I think that's probably appropriate.
I'll ask that be stricken. So,
Stricken
the point
by the
that
judge?
I am making is that previously, Mr. Bankstead had been directed by a court what was and was not appropriate behavior, and that he was not to say anything unless recognized by the chair or permitted to do so by the committee. And frankly, he's abusing the process, and if there's an opening statement that isn't, as you have said, already submitted in writing, then I defer to the Board of Adjustments discretion. But I just ask that he comport himself in an orderly manner and follow the directives of the Board of Adjustment and the attorney, and to stop with the ad hominem attacks, because frankly, it's tiresome.
Against you, Bugle?
Mr. Bankstead, do you have anything to offer us that is
Yes,
not
absolutely.
reading of your pre-hearing brief?
We're putting evidence in differently, though.
After publicly exposing the county's efforts to silence me, the Planning and Zoning Committee backed down, and my Biden sign remained. But my defiance placed a target on my back. Ever since then, Oneida County and the town of Minocqua have systematically weaponized zoning ordinances to harass my business and obstruct my ability to operate. The revocation of my 2024 conditional use permit is the culmination of this ongoing campaign of political retaliation. Now, I'd like to get into the details of how Oneida County zoning process has been used as a tool for suppression of free speech. First off, the efforts by the county were premeditated. The county began orchestrating its campaign to silence the Minocqua Brewing Company and me almost immediately after I purchased my building at 329 Front Street. On March 15, 2021, in response to my Facebook
Mr.
post
Bankstead.
announcing plans...
Mr. Bankstead,
Yes, sir.
we have been more than patient with you. And all you continue to do is to read verbatim from what's already been presented to the committee. So your time for your opening statement is over. Please proceed with your case and present some facts and evidence in regard to the issue.
I appreciate your request for me to stop, but I came all the way here today, and I've come probably to this same room 15 times over the last 4 years, and I've the same types of people and the same whatever your authoritative process is have always told me that I couldn't actually talk to the people who were making decisions about whether or not my company is going to be shut down or not. So with all due respect to you, sir, even though you're a hired gun for the insurance company, I would like to finish my statement, and I plan to before I leave today.
No, you're done. You've been given every opportunity.
No,
to present an
but the
opening
board has
statement.
not been given every opportunity to hear the reasons why they should not shut me down. And sometimes
Mr.
when
Bangstad,
somebody says
Mr.
things,
Bangstad,
yes,
you
sir.
have been advised that the members of the board have received a copy of the pre-hearing brief. They've all had
This
the
is different.
opportunity and have in fact read it, and all you're doing is reading it to us. Please sit down and your attorney can present your case.
After publicly
Please.
exposing the county's efforts to silence me, by the way, I'm letting you know
It's
that
the only way we need
I
evidence.
politely refuse, and if you don't want to hear it,
Really, all I've already been asked several times to not read what we have already read. It's insulting to the board.
I apologize for
And
insulting
you
you.
know,
I think you
we-
actually dressed wonderfully today, and so I hope that counteracts my insulting, because I never really meant to insult you.
Well, you
But I
are.
do plan to act, well, I apologize, sir.
Well, that
I hope we
doesn't
can have
help.
a beer. I invite you to my place after this meeting is over. But I have made my way here
Mr.
to,
Bangstad, please take your seat. Mr. Bangstad.
I respectfully decline.
You don't get to.
I apologize, but I do, because this is a violation of due process, and I am an American citizen, and I plan to read my thing, and you guys are possibly going to shut my business down, which means that I will have no income. So this is a big deal to me. I hope you understand how big of a deal it is.
You're not reading to us, you're reading to the public or the television.
I'm reading to you because I don't think all of you have read the brief. And if you have, then that's wonderful.
I'm sitting here very patiently. This happens to be my last meeting. I'm not sure I'm gonna survive enough hours to listen to the rest of your
I'll give you a beer. It'll revive you, I promise.
For 13 years, and this is the most insulted I've ever been in terms of my intelligence to look at materials and come to a judgment. So I would like the board.
Sir, how do
Mr.
you think
Bangstad,
I feel? How do you think I feel, sir? How insulted do you think I feel after trying to
We're
talk?
gonna take a break. This is enough of this.
I publicly, and after publicly exposing the county's efforts to silence
We're
me,
taking a 5-minute break.
well, they're just going to stop.
But no record right now.
No, there is a record. I'm going to keep talking. So you guys can leave if you'd like. I'm going to keep talking about my speech because these guys
Mr.
simply
Bangstad,
don't want to hear it.
The board has taken a 5-minute
After
recess.
publicly exposing the county's
You're out of
efforts to
order, Mr.
silence me,
Bangstad.
oh, you can leave. I'm fine. Maybe I can just read it. I'll just read it here. Is that a problem with you? You've already. Maybe some people might want to stay on this board that care enough to hear
Mr.
my
Bangstad,
speech.
Do you understand the concept of disorderly conduct?
I understand it. Yes, I understand also the concept of you not being a judge, you being hired by an insurance company to run this meeting, and that this meeting was sprung upon us without any earlier understanding of the structure.
The board is taking a break.
Okay. After publicly exposing the county's efforts to silence me, the Planning and Zoning Department backed down. My Biden sign remained, but my defiance placed a target on my back. In response to my Facebook post announcing plans to use our new space as both a tap room and a hub for progressive activism, former Corporation Counsel Brian Desmond emailed current Counsel Michael Fugel, Carl Jenrich, and Carla Blankenship to discuss amending county ordinances to prevent me from displaying political signs. We have some sort of a quorum here. Let's go. Prevent me from displaying political signs in the future. In his email, Desmond warned, "I'm just alerting you to a problem that may be on the horizon so that you can determine and prioritize." So Brian Desmond.
Oh, okay.
Brian Desmond, it was the corporation counsel for Oneida County and the town of Minocqua. Brian Desmond suggested that me trying to be political was more important to the county to shut me down than to actually listen to what I had to say. That was the second exhibit in my email. From the very beginning, Oneida County has viewed my political advocacy as a problem to be solved rather than a constitutionally protected right. This email was the first step in a coordinated effort to weaponizing zoning laws against me and my company, using regulatory enforcement as a tool to suppress my speech. What followed, the denial of routine parking waivers. Yes, sir.
Hi, since they're in recess, I've got some papers. I'm going to serve them to you real quick, okay?
Sir, papers for what?
It appears to be a summons on an intentional tort with a money judgment.
Okay, guys. So I'm just going to go straight to Facebook here. Apparently, I'm being arrested for criminal defamation right now while we're on a recess.
No, that's
which
not
is
what I said to you.
I'm sure it is.
Papers.
It's called. It says Heather Holmes. It says Heather Holmes right now as summoning me, which is part of the criminal defamation lawsuit. I'm being taken away not because of this meeting, but because of some other thing that the Lakeland Times, Heather Holmes and Greg Walker.
You are not being arrested.
I'm not being arrested.
No, I already explained that to you.
What would you like? What would you like to tell me, sir?
Nothing. I just served you papers. That's it.
Oh, he served me. Oh, I've been served papers. Apparently, I'm being sued in the middle by Heather Holmes and Greg Walker. Apparently, I'm being sued in the middle of this hearing for my cup. This is Oneida County, everyone. This is Oneida County. We have Lakeland Times. Lakeland Times. Greg Walker has just served me papers because he knew this was going to be the only time that I was coming into Oneida County for a while. Because every time I come to Oneida County, I either get thrown in jail or I get served papers. It's funny, the owner of Tilly's, every time I go get coffee there, she's like, Kirk, what did you do this time? Because this is what happened. So I'm going to continue reading. Sir, you want a beer? I can make your last day on the board even better. Okay. Let's continue reading because this is the only chance I will get before this Board of Adjustment meeting that the agenda for this Board of Adjustment meeting was set without us knowing, and the parameters were set without us knowing, and they once again did not allow me to just simply provide my statement and the exhibits. This is probably the 10th time that I've had to do this in front of a board and simply try to present my side. I'll say, has viewed my political advocacy as a problem to be solved rather than a constitutionally protected right. This email was the first step in a coordinated effort to weaponize zoning laws against me and my company, using regulatory enforcement as a tool to suppress my speech. What followed, the denial of routine parking waivers, selective enforcement of zoning conditions, and the targeting of my business, was not a series of isolated decisions, but rather a premeditated effort to silence my company and punish me for my progressive activism. The Board of Adjustment need only look at this early communication to see that the county's actions against me were politically motivated from the outset. Now, let's go to the beginning, where I applied for an Oneida County Administrative Review Permit to start remodeling my newly purchased but dilapidated old gas station in 2021. As part of this process, I requested several parking space waivers, an accommodation routinely granted to other businesses in downtown Minocqua, and expected they be granted because this property was never required to have parking since it was built in the 1930s. Let me reiterate that. It was never required to have parking since it was built in the 1930s. And because there was a seldom used public lot kitty corner to us. So I will present my exhibit, which is the seldom used public lot, to everybody paying attention to me right now, which is right here. Well, you're in recess, so it's okay. From the very beginning, Oneida County has reviewed my political advocacy. Oh, wait, here we go. As you can see in Exhibit 4, this is a picture. Here's Exhibit 4, everyone. Boom. This is a picture of my building taken before I bought it. The manager of this building, a bike rental shop named Z-Best Bikes, was John Camacho. As you can see in this picture, John put all his bikes in the area directly in front of his building and wasn't required to have parking. Our understanding is that John operated his shop in this building for approximately 30 years. Note the space where John put his bikes is what we now refer to as the pork chop. When I bought this building, I was informed that my architect, Chris Nauman, that this little piece of land looked like a pork chop, but was not technically mine, but that I still had plenty of room to build a beer garden on the rest of my property. Chris suggested that I address the pork chop's ownership with the town to ensure that I could still use that piece of land like the previous owner had done. When we asked the town who technically owned the pork chop, they responded that since we were the developer, it was our job to figure out whose land it was. Let me say that again, because some of you might not be paying attention. When we asked the town whose job it was to understand the pork chop, you might be in recess, but it's possible that some people are paying attention. I think that's what matters, does it not? So the town told us to do the research on who owned the land because they didn't want to expend the effort or the time. So I hired my architect for lots of money to do the research for them. We told them that we could claim it because the old owner had plowed and mowed the pork chop for over 30 years. And the concept of adverse possession states that if someone has occupied and taken care of a piece of land for a long time, they have claim to it.
Please stop talking.
We're still in recess, aren't we not?
You probably didn't hear because you were talking.
Oh, okay.
But the chair called the meeting back to order.
Great. Well, thanks. I'm ready to go again.
Now, you've been asked to stop.
Mm-hmm.
So please stop. Your attorney can present the facts and the evidence that you want to rely on, but your time for your opening statement is done.
I appreciate that. I disagree with you.
If you're going to continue,
Yep.
then the chair is going to rule you out of order,
Mm-hmm.
and you'll be removed from the hearing.
Okay.
And if you're removed from the hearing, you're not going to be able to present any testimony. So you have a decision to make for yourself.
I think the decision has already been made by this board what's going to happen today. It's very obvious by how we've set the parameters that don't allow, that hamstring us and how we're supposed to prevent our evidence. So to me, this entire committee hearing is already illegal. So if you don't want me to read my statement, that's fine. You can throw me out of the meeting. But I'm going to do it anyways because what's happened here already today suggests to me that this is not actually government, but this is a plan to just shut me down because you don't like what I have to say. Obviously, this insurance hired lawyer just doesn't like what I have to say.
We've read what you are reading, and I'm reading out of order.
Okay.
So please sit down, Mr. Bangstad.
So I politely refuse to do that, and I'm going to keep reading. The Wisconsin Department of Transportation, politely, by the way, I said politely, and this is a very non-violent thing. The Wisconsin Department of Transportation, because they created a 2-lane highway about 30 years ago, that created this abandoned right-of-way over the top of a few Minocqua roads, or the town. Okay. So if you would, please. Thank you. Okay. Everyone, I have been asked to leave the meeting. I'm being escorted out of the meeting by Officer Sheriff. Oh, is this is this Grady Hartman?
No.
Oh, that would be great if it was Grady Hartman. You didn't look like Grady Hartman, but I wouldn't know given that Grady Hartman's permanently attached to Greg Walker's ass. All right, everyone. Have a good one. I'm being escorted out of the room.